Patent Court, or rather the proposal for a European unitary patent and a patent court. So I'm going to talk to you briefly about the proposal for a single patent covering most of the European Union, possibly in force sometime later this year, possibly, more or less absolutely not in force sometime later this year. More realistic timescale is 2016, 2017, possibly beyond that. I'll talk a little bit about the rules of procedure that have been proposed. They're not yet finalised, so it's just to give you a flavour. And I'm also going to talk a little bit about the Unified Patent Court that goes with the proposal for a unified European patent. And I was thinking a little bit about how to link this to the other talks. And of course, we've been talking about the United States, which is a collection of semi-independent states that have a unitary patent and have separate courts of first instance, but a unitary court of appeal and a unitary Supreme Court. And that's very much the model of what's being sought to be achieved in Europe. And the advantages are obvious, and I'll go through them in a little bit more detail as we go on. And there are some notable disadvantages, which I'll also touch on in more detail. So the kind of timeline we're at the moment, obviously we've had a European Patent Office since the 1970s, discussions in the 1960s onwards. And at that same time, it was discussed the possibility of having the European Patent Office grant a patent that took effect in the whole of Europe. And that proved much more difficult to agree on. So we ended up with a compromise situation, which was the European Patent Office, which I'll talk to you about in a minute, but with separate national patents being validated after grant. Moving forward to the present day, discussions were reignited in early 2010, 2012 onwards, and the European Parliament has agreed in principle a selection of the member states based on a method of enhanced cooperation have agreed on the idea of a unitary European patent and a unified European patent court. And as I said, the timescale now looks realistically to be 2016, 2017, possibly later. So what we have at the moment is a European Patent Office. Examines patent application, very high standard of examination, one of the busiest patent offices in the world, and following that examination, hopefully approves a patent for grant. That patent then needs to be validated in the designated states of interest. So on filing a European patent, you designate a list of states that are signatories to the Patent Convention, and you can then choose from those states as to which ones you want to validate your patent. If you then seek to enforce that patent, you enforce it as a national patent. So a UK patent, a German patent, French patent. And the result of that is you can have different outcomes. You can have a patent that is valid but not infringed in the UK, and you can find a patent being infringed but invalid in Germany. The difference between the UK courts and the Dutch courts in the recent Isotalipram litigation highlights that very clearly. The idea with a unitary patent is that you essentially do away with that need for a bundle of national patents. So you would be given the opportunity to convert, up to 1 month after grant, a whole section of that European designation into a unitary European patent, leaving out just those countries that are not signatory to the idea of this European patent, and those countries are listed there. And that unitary patent would also come under the jurisdiction, eventually, of the Unitary Patent Court, which I'll talk about later. So there are some notable countries who have not signed up. Obviously, some countries, signatories to the European Patent Convention, are not members of the EU, Switzerland and Norway in particular. And Spain and Italy were essentially unhappy with some of the proposals and didn't move forward with that legislation. So some of the benefits, essentially one patent across the whole of Europe gives you uniform protection across all the member states and allows you to deal with that patent in a single action across all member states. So things like amendments, licensing, recordal of assignments can be done centrally at the European Patent Office and take effect throughout Europe. Also, the potential to get rid of a lot of the translation requirements. The proposal is essentially, as present, claims will need to be translated into all 3 official languages of the EPO, English, French and German. During a transitional period, the whole specification will need to be translated into at least 1 other language, as long as there is, between those 2 languages, an English language version. But eventually, the idea is that Google Translate will essentially take over. Google Translate system's getting better and better, and in theory should be able to provide you with a translation of the whole patent. So, as we're currently looking at procedures, I'll just talk very briefly, but the idea is that within a month of grant, you'll be able to convert into a single unitary patent, and that will be available for every European patent application that's pending when the procedure starts, and any European patent application filed thereafter. And that unitary patent will be kept in force through payment of a single renewal fee. We don't yet know how much, and that's an important point. So potential advantages, hopefully lower renewal fees, a single payment rather than, say, 30 payments across a bundle of national validations should, in theory, be cheaper. Obviously lower cost for translations, and easier enforcement, a single court, a single action to enforce a patent. However, the disadvantages will come in cases where you would maybe have only sought to validate your European patent in a small number of European states. Maybe UK, France, Germany were all that was of interest, and you were only looking at 3 lots of validation costs, 3 lots of renewal fees. The combined renewal fee could be a lot higher than you would have faced there. And the big disadvantage comes as that European patent relates to the European Patent Court. A revocation action would apply across the whole of Europe rather than just in one territory, and you have to use a new and untested court. And I'll talk about that in a minute. So the unitary patent, generally speaking, seems like a good idea. The negatives come from how that relates potentially to the Unified Patent Court. So the Unified Patent Court would essentially be a centralised court that would deal with all post-grant actions for a unitary patent, and eventually non-unitary patents that haven't opted out of the scheme whereby the Unitary Patent Court would have jurisdiction. And that would take over the role of national courts, essentially in respect of validity and infringement actions. And the timescale for that coming into force is about the same. So in typical European fashion, there were many months of arguments about where the court should be based. And at the moment, it looks like a central court of appeal in Luxembourg, and then 3 central divisions all splitting the subject matter between them, engineering being largely heard in Munich, pharmaceuticals cases in London, and electronics and telecoms cases in Paris. At a lower level, courts of first instance could include local and regional divisions which can be set up throughout Europe. Essentially, any European territory that deals with currently over 100 patent cases a year would have a right to set up a local or regional division of the court. It will not affect how the European Patent Office operates at the moment in terms of opposition procedure. So, as you know, 9 months after grant of a European patent, you can oppose it centrally at the EPO, get European-wide revocation, and that will function as normal. Appeals from the EPO will still be heard by the EPO Boards of Appeal, and there'll be no appeal from the EPO to the Unified Patent Court. I'm just going to skip through some slides about some rules of where to bring cases and how the court will be composed, but I can send you copies of these slides if anybody wants a little bit more detail. The unitary patent will fall under the jurisdiction of the Unitary Patent Court. For a transition period, national rights that were separately validated and not as a European patent will have the right to opt out upon payment of a fee. If you opt out, you do have the right to opt back in again, so that gives you a bit of additional flexibility. And that says the same thing. So, issues relating to the cost of the court are still proposed at the moment. The court is proposing to generate most of its income from opt-out fees, at least initially. That's around €200, so it's hard to see how that will generate sufficient funding for the court. But then the interesting bit comes into how we look how that will affect you when seeking to decide what's best for proceeding with your important cases. So, as I say, the key dates are 2016, 2017, maybe 2018, where we're looking at this legislation coming into force, depending on whether the legislation is successfully ratified in European member states. And the end of the transition period where you can opt out, which will, based on a 2016 entry into force, will be around 2023. How should you use this to affect what you do going forward? Well, we would recommend, at least initially, that you be aware of the possibility of opting out. And we'll look at why now. Essentially, this is a very risky situation to place an important patent in. You can be attacked centrally, you can be found to be invalid across the whole of Europe, and that decision will be made by a court that is brand new. We can't look at the case law, we can't look at how the judges view various issues, we're completely in the dark. And of course that will develop as the court hears more cases and deals with more patents, but I would bet that nobody would feel too comfortable about their most important patent rights being the guinea pig for that particular experiment. Also, we should be looking to be as proactive as possible using the European opposition procedure when we're on the offensive, because in stark contrast, the European opposition procedure has over 30 years worth of case law. The European Patent Office is very consistent in the way it looks at validity matters, and that 9-month window will be crucial if attacking the validity of third-party rights is important. Stay on top of developments as well. We're talking about proposals at the moment. These proposals look as though they're going to come into force. We don't know about the timescale, but it's got as much momentum behind it as it's ever had. And it's important to stay in contact with your European patent attorney, to get your European patent attorney to advise you on the likely timescale, any changes, and how that's likely to affect your most important patent rights, and offer their advice. And as I said, this really comes down to how you deal with your most important cases. Maintaining that flexibility in terms of whether you're in or out of the new system is going to be important. Subjecting yourself to the possibility of European-wide invalidity based on a court with very little experience is a scary prospect. Following the transition period, really, we're left with this decision to either plumb for the new system, the unified court, a unified patent, or to go back 40, 50 years and take your PCT application into Germany, UK, France, Italy, etc., and prosecute a bunch of separate national patents. Now, we will know, hopefully, a lot more about how the unified court is functioning at that point, so we can make much more of a decision about how risky it is to go ahead with a unified patent. But the idea of having patent prosecution in every state in Europe separately certainly doesn't fill me with too much happiness. So I'm happy to take questions at the end. I'm not sure whether I'll be able to shed much more light on it. As I said, it's all still a bunch of proposals at the moment, but hopefully that gives you a flavour of the situation as it stands at the moment. Thank you.